Well, good morning, everyone, and welcome to our program this morning on defamation, social media, and your business. So we're pleased to have you here with us today. We've got a very interesting program that we're going to launch in just a moment. In case I haven't met everyone on this call, my name is Tim Sink. I'm president of the Greater Concord Chamber of Commerce. We've got a couple of upcoming events I'd like to bring to your attention. Our annual State of the State lunch is coming up on Tuesday, March 22nd at 11:30, and that is at the Grapponi Conference Center with Governor Sununu, so we can learn all about what's happening in the state of New Hampshire on March the 22nd. And then on April the 7th, we do our annual State of the City breakfast with City Manager Thomas Spell and Mayor Jim Boulay. We'll also be recognizing a Police Officer of the Year and a Firefighter of the Year. So that is an event on April 7th. And then I finally want to bring to your attention Business After Hours, a new brewery in town, Feathered Friend Brewing, and Smoke Show Barbecue. So that's Tuesday, April 12th from 5:30 to 7 p.m. So please join us, and we have all kinds of other events that are upcoming. You can check out our website and see those and register for upcoming events. We're really pleased to have two excellent presenters with us today. This Orr Reno Webinar Series is very informative. We have some wonderful expertise that we're able to tap into, and today's program is very, very important to everyone who does any sort of marketing on social media. So I'll introduce the speakers, and then I will turn it over to them. But we have Bill Chapman from Orr Reno, and Bill's focus is representing the media, journalists and authors, appellate practice, trusts, estates, and estate administration, and businesses seeking tax exemptions or abatements. Bill has represented a number of national, regional, and local media organizations and journalists in access cases under the First Amendment, the Freedom of Information Act, and New Hampshire's Right to Know law, and in defending against defamation and privacy claims. Bill is a very well-known individual here. He is a well-known community leader, and I should mention that he was recognized by the Chamber of Commerce in 2017 as our Citizen of the Year. Our other speaker this morning, also from Orr Reno, is Elizabeth Velez, and after law school, Elizabeth clerked for Justice James Bassett at the New Hampshire Supreme Court, and also for Chief Judge Lanya McCafferty at the United States District Court for the District of New Hampshire. After these clerkships, she joined the appeals unit for the New Hampshire Attorney General's Office. She successfully represented the state before the New Hampshire Supreme Court when defendants appealed their convictions on evidentiary and constitutional grounds. Elizabeth represents clients on litigation matters, including complex commercial litigation, personal injury, land use, and general civil litigation. You will be able to ask questions throughout this presentation by either raising your hand at the button on the bottom of your screen. You've got a raise hand button, or you can also type a question into Q&A, and it's okay to come up with those questions during the presentation. So at this point, I'm going to turn it over to Elizabeth and Bill, and thank you so much for being here. We're excited to hear your presentation today.
Thank you, Tim.
Thank you very much, Tim, and it's great to be here. So just want to reiterate what Tim said. We really welcome your questions at any time. We don't want this to have to be 45 minutes of you listening to us with that burning question. So if you go down to Q&A down at the bottom, which I can see someone has already done, asking, will the recording be available after the presentation? Yes, it will. I've been told that it will be sent out shortly after the presentation. So yes, this is being recorded and you can see it. If you have any questions, feel free to go down to that Q&A box at the bottom of your screen, type it in, hit enter. Only Tim and us will see them. So if we miss a question that's applicable, Tim will stop us and have us answer it right then. Or we might save it till the end, but hopefully we'll answer as we go. If you want to ask a question out loud so we can actually hear each other's voices, there's also a raise hand button at the bottom. If anyone raises their hand, I believe Tim will see their raised hand, ask them to say what their question is, and we'll do our best to answer it. So please feel free to ask questions at any time.
Well, let me just say one thing that may sound counterintuitive to people who've lived here for quite a while. You know, New Hampshire, the little state in the Northeast, up near Maine, the Canadian border. We actually have a very rich tradition of defamation law. by a quirk in our law. For a number of years, we allowed people to bring defamation cases for a much longer period of time than many other states. And that was changed back, I think, in the 80s. Went from 6 years to 3 years, which is what it is now. But as a result of that, publications and people such as the New York Times, St. Martin's Press, published a book called The Powerhouse by a well-known lobbyist in the Reagan, during the Reagan administration. Jim Kelly, you'll remember, quarterback for the Buffalo Bills, published a book called Armed and Dangerous, which became such in a suit against him that was here. Members of the Beach Boys sued over a book called Wouldn't It Be Nice? Again, sort of an ironic title when you think about defamation. And in addition to that, publications like USA Today, Business Week, Dun and Bradstreet, all have been sued here, and that's why we have a very well-developed body of defamation law. So let me just emphasize, the one thing we want to make sure we do today is if you've come to this or during this program, you've got questions, make sure we answer them. And if for whatever reason we're not able to, give either of us a call afterward. At any time, we'd be happy to answer them. So let me turn it back over to Elizabeth, and she's going to talk about social media.
All right, so what is social media? It's, what it is. It's what you're using to promote your organizations and businesses. Facebook, Instagram, Snapchat, TikTok, Twitter, YouTube, and probably a lot of other platforms that I haven't discovered yet. There is not, however, a special set of laws so much for social media defamation as opposed to other things that one would speak or write or say to another person. So while social media has a special set of platforms and a special set of laws, which we'll get to later about when the social media platform can be held liable for defamation, for the businesses posting or the individuals posting on social media, regular defamation law applies. And we will do our best to explain that to you as we go, but please do interrupt with any questions you may have.
So what is defamation? Well, it begins with a publisher, the person who makes the post or, excuse me, does the communication. And defamation is a statement of fact. And I emphasize fact. It's got to be fact-based. And it's a false statement of fact. It's communicated to a third person, can be one or more third parties about a subject, and it injures the subject's reputation. And that injury has to be on the basis of a reasonable understanding of the statement. I had a case many, many years ago where I represented the Berlin Reporter. It did an editorial about a member of the community, accused that member of making obscene phone calls, and the court ruled that the plain, the plain meaning of obscene phone calls would injure one's reputation. So that's an example of what I mean by a statement of fact that injures reputation. Posting on the internet is considered to meet the communication requirement. Obviously, when you post on the internet, you are posting, depending on the platform, you are posting literally to thousands and maybe hundreds of thousands or millions of people. You can defame a small group. Small is not well defined in the law, but the example I gave in the outline of a local police department with only a few members, if you say that police department is engaged in improper conduct, any member of the department could be considered to have been defamed, reputation injured, and would be able to bring suit over that statement. We're now going to turn to opinion. And let me give you a little backdrop on opinion. In 1974, the US Supreme Court decided a case in which it stated under the First Amendment, there's no such thing as a false idea. I think as time went on, the court began to realize that it had really overstated what it intended to rule in that case. So more than 15 years later, it cut back on that broad statement and decided a case in which it began to develop rules around the idea, which you can think of as opinion. And I'm going to turn it over to Elizabeth to explain that to you.
So as Bill said, in order for something to be defamatory, it has to be a statement of fact. But what is fact? And that's one of the main analyses that happens when courts consider defamation. So hyperbolic language that can't be proven true or false isn't fact. Calling someone sleazy isn't a fact. It's an opinion, it's a statement that can't be proven. So that's not actionable under defamation. Doesn't mean you can't be sued for saying it, but it means that a court, to get to a court, it's going to say, well, no, that's not what we're talking about when we say defamation. It can't be proven. Other kind of hyperbolic language would be calling a journalist the journalistic scum of the earth in a letter to the editor. It's not something you want said about you, but it's not capable of being proven true or false. It's a statement of thought, of opinion, using language that kind of on its face is clear. It's not really, there's not a fact underlying that. Courts have also found that saying something is a ripoff, again, hyperbolic statement of opinion, can't be proven true or false. But if you're in a state that says, that has a criminal price gouging law and says it's illegal to pump up prices during a hurricane, and instead of saying that the local grocery store is ripping off customers, you say this grocery store is engaging in price gouging, that could be defamation because there's a statement of fact that could be underlying that. Courts have also held that, for example, language like calling an entity a patent troll, not defamation, because it doesn't have a precise meaning. So that kind of language that is hyperbolic, imaginative expression that can't be verified, that's in opinion land. That said, saying things like, I think such and such, I believe, it's my opinion, that kind of language, although one would think kind of on its face, sets off an idea as being an opinion, isn't enough to necessarily protect the speaker in defamation. And the reason why is because if you say, for example, I think Jim is an alcoholic, and a person hearing that or reading that would think, gosh, the speaker must know something I don't know. They wouldn't say something like that if there wasn't some fact perhaps in their mind that they know, they've not told me what it is, but that they know that supports that opinion. So the Supreme Court held in like the 1980s that use of kind of magic language, I think, I surmise, it's my opinion, doesn't necessarily give the speaker a get out of defamation jail free card on whatever they might say next. If the language read by a normal kind of reasonable person would think that there's some fact underlying that statement that the speaker isn't sharing, and that that statement can be proven true or false, and it's defamatory, it puts someone in negative light, then a court could allow that defamation case to move forward. So that, yeah, I think those kinds of magic words aren't enough to necessarily protect a speaker. That said, the context of a statement really matters. So, for example, if a speaker in a tailgate party says, "I suspect that the Patriots will win the Super Bowl," it's pretty obvious to a speaker that there's no special knowledge necessarily that that tailgate partier has. When they say "I suspect," they mean "I'm guessing the best I can." But if an exterminator has come to your house and they've checked your rafters, and after investigating your house, they were to say, "I suspect you have termites," the context of that statement, both what the exterminator's background, what he's done just before he said the statement, would suggest that when he says he suspects, there's something back there. And that's relevant to what you're posting on your social media sites, because, for example, if you're a builder and on your social media site, whoever's posting says something like, I think that building being built next door doesn't come up to code, that's going to be read differently because you're a building site than if someone said that about their neighbor. Similarly, for healthcare or other kinds of statements that your organization may make, if they're on the topic of your organization's expertise, then any statements that could read as opinion, if given by someone on the street, may be seen differently. So something to keep in mind while you're posting online about whether or not something's really an opinion or whether it's something that implies that there are other facts out there. One other thing to add, if you make a statement and you give all the reasons why you think that statement is true. So to use an example, every day at 5 p.m. when I get home, I look over my fence and I see my neighbor in the backyard and she's always holding a glass of alcohol and has the bottle next to her. I think she's an alcoholic. Statement of fact, defamatory puts them in a negative light, but you've given all of the reasons why you think alcoholic is your end hypothesis, your end opinion. And so a court's not going to find that to be defamatory because you have laid out all the reasons that you've reached your opinion, and therefore the hearer or the reader is free to make their own decision based on the available facts which you've provided. If, however, you just say, "I think my neighbor is an alcoholic," that's going to be seen differently by a court because it implies that there's fact out there to support the opinion, and there's nothing given to the reader or listener to reach their own surmise or opinion and to see if they agree with you or not. So as I said, to the courts, context matters a lot, but what they're really trying to decide in seeing whether or not something is protected opinion or actionable fact is whether or not the statement implies there's something else out there that's factual and defamatory. Have anything to add, Bill?
Yeah, this is really to underscore Elizabeth's point. This is really a situation where less is not more. The more complete you are, the better off you are. So if you're going to go online, you're going to make a statement about a competitor, organization, or individual. The more you say to back up what you're saying, the better off you're going to be. So we've talked about statements that are defamatory, but not all defamatory statements give rise to legal liability. The missing piece is fault. And Elizabeth's going to talk about fault in a minute. But what I want to emphasize is the publisher has to be at fault. If the publisher is an organization, it is going to be communicating through an employee. Whether or not the communication identifies the employee is really irrelevant. So if you've got a social media site and you've got people posting to it. I can't emphasize enough that you want to have clear guidelines about who can post and what they can post about. And if they privately, for example, have a Facebook account, you want to have your guidelines make very clear that when they're posting on their private site, it's clear that that's what they're doing and that they're not posting on behalf of the organization that employs them. So Elizabeth, what does fault mean?
Fault means, well, that it's your fault, but courts use different standards to figuring out whether or not legally it is someone's fault, as in they can be held liable. So there are two kinds of fault, and they apply to different kinds of people in the public sphere. And when I say people, I mean organizations too. So there's negligence, which has a pretty imprecise standard. It's, did you do what a reasonable person would have done in your situation? Nebulous, unfortunately, but that's how negligence works in law, in defamation, in tort, just kind of how negligence works. There's also actual malice, which means that the speaker, actual malice thinks about what the speaker actually thought and knew at the time that they made the statement. And in order to be found at fault under the actual malice standard, a speaker has to know that what they're saying is false and say it anyway, or act with reckless disregard for the truth. They don't care, they just do it. But it's thinking about what the speaker actually thought or knew, not what a reasonable person would have done. That's the harder standard to meet. So which standard applies to which person? Well, there are kind of buckets of people in defamation law. If you are a public official, you're elected governor, president, you're head of an administrative agency, you have some kind of public face, the actual malice standard applies. And the same actual malice standard applies if you're something called a general public figure, which is your Clint Eastwoods, your Kobe Bryants, your celebrities, people who are in the public eye in a entire way, the Kardashians of the world. And the idea is that the higher actual malice standard applies to them because they've put themselves in the public sphere. And as an entity or a person who's so thoroughly in the public sphere, everything's kind of within the bounds in a way that doesn't apply for your neighbor, your private neighbor. And so courts have held that actual malice, a higher standard applies because public figures and public officials have voluntarily kind of taken on the role that they have, but also they have access to the media and so are in a better position to refute anything that might be said against them. So the higher actual malice standard applies to public officials and public figures like celebrities.
Let me just interrupt on this point. On public officials, the case that established the actual malice case, some of you may have read about the controversy over the case. It's called New York Times v. Sullivan, and it involved a public official. And part of the reason why, or perhaps part is understating it, the reason why the court developed the actual malice standard is it wanted to encourage discussion about matters of public concern. And typically public officials are dealing with matters of public concern that affect all of us day in and day out. And the court, consistent with a guiding principle of the First Amendment, which is better results come from more discussion. That sounds probably a little anomalous today, but that is the underlying principle of the First Amendment. And so that's why the standard is higher.
And on that idea that more knowledge comes from more discussion, the courts later decided that that actual malice standard also applies to something they called limited public figures, which really means if someone has kind of inserted themselves into a public controversy that is ongoing and is seen as having some authority, or at least has claimed some authority on that topic, they've inserted themselves, then that actual malice standard also applies to them. So for example, if there is a blogger who has built a reputation for having, say, a blog about autism or some public controversy like that, then for statements that are about the blogger on that topic that they've put themselves in the public sphere, autism, that actual malice standard would apply. But a different standard, negligence, applies to kind of everyone else. So your neighbor, the owner of the grocery store, just people in general, it's the negligence standard. And that, for that, fault is, did the speaker act as a reasonable person should have done? Which asks the question, what is reasonable? So if your organization is making on a social media site a comment, it's worth thinking about who they're making it about, and if it's a topic that's already in the public sphere. And then thinking about, well, what is reasonable? And courts have found that researching, kind of like, I'm about to make this statement, what have I done to say if it's right or not? Court will look at those kinds of efforts that one has made. Is the source of the statement, if you're republishing something, generally trustworthy, and why or why not would that statement be, or that speaker, I'm sorry, be generally trustworthy? And what attempts, if any, has an entity made to find opposing views? Now, it doesn't mean that every post needs to go through these hurdles, but if a post is going to be about a competitor or about an issue that could cast an organization or a person in a negative light, it's worth giving some thought to these things before the post goes on. And you might want to think about what is reasonable or prudent in making your social media policies that your organization likely has if you have a social media site. So it would be thinking about who can post on the site. What do they need to do before they just post something? Does your organization repost other people's comments, or do they only post their own? Things to think about as you use social media. And just to put out an example of what courts have and haven't found to be negligent. One example, so there was, for example, if there's a battered women's shelter, and in one of the cases, the shelter had a newsletter that posted about someone who had come in and an experience that they'd had, and there was a defamation case. I'm sorry, someone brought a defamation case saying that the organization hadn't done enough to see if what she said was true or not, because it definitely put someone in a defamatory light. And the court said, well, it's not practice for a battered women's shelter to kind of interrogate statements that people make to them. So even though the shelter didn't do a lot to figure out the background or see the truth of what the woman said, that wasn't found to be defamation. So the courts really focus on what a person would be expected to do, or an organization to be prudent, to have given some thought to whether or not something was true or not. So I just want to pause for a minute. We've said a lot about opinion and fact, and about when you can be found at fault or not. Does anyone have any questions? I see that there's someone maybe has said something in the chat, which we can't see on our end. There's the Q&A box. So does anyone have any questions?
Well, I put something in the chat to remind folks about questions and how they can ask them, but I do have a couple of questions, and you may be covering this later in your presentation, but I'm just curious, from your experience in dealing with these issues, what kind of financial exposure is there in, say, a typical New Hampshire defamation case? How painful is this for someone who is, maybe is guilty of the defamation?
Yeah, so we are going to get there, but shall we just jump in there now? Okay. So how the damages are based on kind of how much the statement hurts someone. If it's the kind of statement that accuses someone of a crime or of engaging in behavior that obviously harms a reputation, for example, accusing a cashier from stealing from the till would hurt. It doesn't take a lot of connecting the dots to figure out that hurts them. Courts don't make individuals prove specific damages, the courts kind of say, well, generally this kind of statement would hurt someone in this way. So they don't have to prove actual damages in the same way by showing like, here's my medical bills, for example. But if a statement hurts someone by causing loss of wages, loss of job, they need medical care in a different way, those kinds of special actual damages, like where someone can show a receipt or prove the damages in a specific way, the speaker can be on the hook for that. Bill, what have you seen that range in your experience?
Well, not New Hampshire so much, Tim, but nationally, there have been huge verdicts. And I think they really are a reflection of the times where, we live in a period where there's a lot of divisiveness. So it may reflect simply a lack of the publisher, the way the publisher is viewed by the jury. Courts make an extra effort to try to screen out people who may have prejudice against the defendant publisher. But general damages ranging in the vicinity of hundreds of millions of dollars is not that uncommon today. And again, I emphasize general, sometimes referred to as presumed damages. As Elizabeth said, the nature of the statement is such that it's going to injure somebody's reputation. In New Hampshire, we haven't had that many recent verdicts. Publishers, whether organizations or individuals, have generally fared fairly well. But if an organization got sued and the subject could demonstrate a loss of business, went back and over an X period of time, had so many customers and that dropped off substantially, that would provide the basis of a special award of damages. Does that answer your question, Tim?
It does, thank you. And we have another question for you. It says, can you talk a bit about if someone leaves a comment on your organization's post that is negative? Some organizations remove comments that might be defamatory. Some organizations keep the comments on the posts and reply to them. Do you have any advice when it comes to someone putting something negative on your organization's platform?
Well, that's covered by the very end of our outline, but we'll address it right now. It's section 230 of the Communications Law, which is the last slide of the presentation. And if you're running what's referred to as an interactive computer site, meaning people can post on your site, you are not responsible in most cases for that post. The law gets a little bit intricate. So if you're going to allow people to comment on your site, you probably want to go beyond what's in the outline and look at some of the sources that I reference in the outline that have fairly complete descriptions. For example, you can make minor edits to a post, but if you significantly alter the meaning of the post, then you're going to be considered a publisher as well. Now, what your question hasn't directly asked, Tim, or what the questioner didn't directly ask is, while the organization that is hosting the site is not going to be held liable under section 230, the poster is. The poster is treated as the publisher. So if I go on the chamber site and I make a comment about one of its members that's defamatory, the chamber is not going to be sued. I mean, it could be sued, but it will not be held liable under Section 230. But Bill Chapman's going to be held liable if I'm at fault in my post.
Yeah, and something to add to that, the question says some organizations remove comments that might be defamatory. Some keep the comments on the post and reply to them. So speech by the speaker can be held, you can be held liable for that speech. So if you reply to something that is defamatory and your reply can be seen as asserting fact that is defamatory, that's where you could get into trouble. You don't have to keep, the post on in the first place if you don't want to. The First Amendment doesn't require allowing individuals to say anything they want on your Facebook page if you don't want to. You have editing power, and how you choose to use that could be up to the organization. But if you say something back, you could be held liable for what you say, because that's your speech.
Great, that's very helpful. Thank you.
I mentioned at the outset that we have a rich tradition of defamation law. And one of the quirks in that rich tradition, we are only one of 13 states that makes defamatory statements criminal, or not all defamatory statements, but some defamatory statements. And that is RSA 644:11. I have set forth the text of the statute. And you will see that it says purposely communicates to any person orally or in writing. And it has to be about a living person. Now, there is a case that was decided by the federal court fairly recently, in which the court, in giving the background of the case, mentioned that the individual had posted on Craigslist and posted on an online newspaper, and 2 police departments, Hudson and Exeter police departments, charged the individual who made the post with violating the statute. The case does not explain why posting on the internet meets the communicates to any person language in the law. So that's a bit of a mystery to me, but because there's precedent out there, I felt that it was important to bring it to everybody's attention that posting on social media, depending on the circumstances, might lead a police department or the Department of Justice to bring a criminal action under this statute.
Although before everyone gets too terribly scared, the language of the statute does say knows to be false. So there is some sense of, that what you're saying isn't true. And so it's where it's closer, it's more like the actual malice standard. It's not identical, but it's less likely that you're probably going to do it inadvertently.
So to pick up on that, knows to be false, so that is a subjective standard, meaning somebody's got to get on the witness stand and say, I spoke to Bill about it, and Bill told me that he didn't know whether it was true or not, but he was just really angry at this particular organization, so he went online and made the post. That's the sort of evidence you'd have to meet the knows to be false requirement that Elizabeth referred to. So moving on to the next slide about repeating a defamatory statement. I mentioned the old common law rule that a tale bearer is as bad as a tale maker. It really, in the age of the internet, has come back to have totally new life because it's so easy to forward on a post. And when you do something like that, you're repeating it. So you're the tale bearer, and someone would have to demonstrate that you were at fault in reposting that or forwarding it on to a group of people. And that could lead to liability. So then we get to the question that Tim brought up, but let's just go back through the basic rules again, Elizabeth, on that.
Sure. So damages, as I mentioned, there are two different kinds: general damages, which are presumed damages. It's damages that are naturally flow from a certain kind of statement that's pretty bad, put someone in a criminal or negative light that would quite obviously harm their business reputation. And then the other kind of damages, special damages or actual damages, whoever's asserting they should get those damages needs to prove. So I really lost this job because of what you said. I really didn't get this job because of what you said. These are actual medical expenses that I needed for counseling because of what you said. So those need to be proven in a more specific or exact way.
I mentioned at the outset that the law now is you have 3 years to bring a case for defamation from the time of publication. And courts have struggled in some cases with, well, when was the statement published? Because it's so easy to initially publish now or to republish. And to be safe, if you believe somebody has defamed you or your organization, you want to start with the original posting of that statement and not get the whole issue tied up in a knot that has to be untied by a court. There is insurance coverage for defamation. It's fairly common, and if you're going to run a site, I would encourage you to speak with your insurance counselor, find out what the coverage is, how much it costs, what it covers, what the limits are, because by running the site, you are exposing your organization or yourself to potential liability. The final topics we want to cover are if you realize that you've inadvertently defamed somebody, said something that was certainly going to injure their reputation. You know, it's so easy today with the availability of the internet to post things, and if you don't carefully think about the post beforehand or after you've posted, the omission of the word "not" could make all the difference in the world. 3 letters that expose you to liability. So what do you do if you've inadvertently omitted "not" or included "not" and you've defamed somebody? Once you realize that, whether you realize it or somebody brings it to your attention, take it off the site. Consider speaking with the subject of the statement. You may want to talk to counsel first, get counsel's advice about, you know, what you might want to say. Consider an apology. I always look at these situations as you're in front of a jury. What would you like to be able to tell a jury you did in this circumstance so the jury understands it was inadvertent and you are sincerely sorry about it. And thinking about it from that perspective, I think is quite helpful. And as we've indicated in the outline, for sure, no matter what the subject says, you want to put your insurance carrier on notice of the inadvertent mistake. But turn the coin over and you want to make a statement about some organization that could be conceived or considered to be defamatory. What do you do? Well, the first point that I mentioned is recognize, particularly if you're an organization, that all your internal communication is potentially discoverable if there is a lawsuit. So if you and your colleagues are going back and forth by email about some subject that you want to criticize, bear in mind that all of that back and forth communication is potentially discoverable in a lawsuit. That would be true, particularly true in an organization, but also true, in a family or just an individual context. If Elizabeth and I are talking about somebody just privately, our communications are potentially discoverable. So you want to be very careful about that. You want to think about, who is the individual, what's the standard that individual would have to satisfy to demonstrate fault. You want to ask yourself, where's the individual located? If it's in New Hampshire, as I said, we've got a well-developed body of defamation law, and any lawsuit would be governed by New Hampshire law. But if the individual is in Massachusetts, in California, somewhere else, that's where the individual likely would bring suit, and that state's law likely would govern whether or not the statement is defamatory, whether or not you are at fault. In that circumstance, I would highly advise that you confer with counsel before making the statement, before posting it. There are not a lot of lawyers that focus their practice on defamation, but the sources now with the internet are plentiful. So there are a number of sites that will allow your counsel to look at the defamation law in the state of Washington or Oregon, wherever, and provide guidance on what you can say, what you need to be careful about. And then you want to make sure that you've literally turned over every leaf to ensure that what you're going to say is accurate and it's not false, because it's only the false statement of fact that gives rise to a claim of defamation. So you want to consider, how did you acquire the information? Is it based on sources? And if it's based on sources and not your own independent research, how did the sources know? And are they credible? What do you know about the sources? Again, a perfect example, you're on the witness stand, you're asked, well, why did you believe what you said was true and accurate? And to be able to give a complete description of everything you did to demonstrate that you were not at fault, regardless of what the fault standard might be. Anything you want to add to that?
Yes, pragmatically, Bill's example about what do you want to say if you're on the witness stand is a really good thing to keep in mind. But you also might want to think about how you avoid being on the witness stand at all. And so if you want to use social media to criticize someone, you want to make all of these steps so that if you are sued for defamation, you have a really good case, and hopefully it'll get thrown out before it ever gets to a jury. But if you do use social media to purposefully say negative or potentially defamatory things about other people, you do open yourself up to potentially being sued by someone who wants to say that you crossed that legal line and what you said is defamation. So you might want to, again, as you create your policies for how you use social media, you might want to think carefully about how you use that very public face to say things about other entities.
I think the final comment that I would make is putting something on social media. It's a good example of really thinking through what it is you're going to say. I was lucky enough when I began practicing at Orr Reno. My mentor was Bob Reno. Some of you who are longtime residents of New Hampshire may recall Bob, very well regarded citizen of not only Concord, but of the state. He had what I call the Reno rule, which is you compose something, you put it away for a while, you come back to it, you make sure it says what you want to say, and then you, in those days, then you sent the letter out. Reading a biography of Abraham Lincoln, I realized that Reno may have gotten the rule or the practice from Abraham Lincoln, who is reputed to have composed messages, put them in his top hat and save them for a few days, and then he would take off his top hat, take a look at them, and decide whether he wanted to go forward with the statement. We've already covered section 230 based on a question that Tim had. If there are any other questions, we'd be happy to answer them now, or if they occur to you later on, we'd be happy to answer them at any point. And thank you for your time.
Well, thank you both. And I love the Reno rule. I've employed it myself, and I have never regretted employing the Reno rule, but now I have a name for it. I also love the advice of, before you post something that could be considered defamatory, that you picture yourself on the witness stand trying to answer that question. And if you can't really answer it very, very thoroughly, take a pass at it. I did have one final question I wanted to put out. And, when you look at online media, say you go to a Concord Monitor piece, for instance, and there's a story about something happening locally. And then you've got these folks that will anonymously post all kinds of nasty stuff. And I've been the subject of that more than once. And it just seems like folks are really not conscious of this type of liability. So is it fairly uncommon, at least from a local regional perspective, that these types of defamation suits happen and that folks are found liable? Or, can you give me a sense for how often that happens?
For the anonymous poster,
Yes.
there is a way to penetrate that, and courts will order the site that hosted the post. And I'm not conversant with all the intricacies as to how you find out who the ultimate poster is, but there are ways to do it. So that's not, an anonymous post that's critical of Tim Sink is not going to mean that Tim doesn't have an ability to bring suit against the poster, not the monitor, but the poster.
Well, thank you for that. And thank you both so much for this. This is great information for our members and for organizations locally. I believe that you made those slides available for folks that would like to access them, because there's some great notes on there for, just standards for people to follow.
Yeah.
And as folks on this call know, we did record it. This will be archived on the Chamber website, and I know it's going to get a lot of traffic. And that'll probably be available by sometime tomorrow, I'm guessing. So if there are no other questions, Elizabeth, Bill, thank you so much for this. I love the Orr Reno legal series, and this was very, very relevant to today, and really appreciate a very thorough presentation.
Thank you.
Thank
Thank
you.
you for the opportunity.
Thank you, and I'll see everyone else at an upcoming Chamber event. Have a great day, everybody.